All right, welcome everybody. I know a few of you are still getting your lunch. That's fine. Take your time. We have hopefully enough seats for everybody. I'm John Haig. I am the co-director of the Mosavar Rahmani Center for Business and Government. It's great to see so many of you here. A couple things. We are very, very fortunate today. We have Jon Sallet with us. And Jon is a senior research fellow here at M-RCBG. And has been for a few years. He and I are also going to teach a seminar class the second half of this fall semester, BGP 215 M for all of you students. And it is called Big Tech and the Importance of Competition, Public Policy in the 2020s. Jon has a long history. He's had government service he was General Counsel of the Federal Communications Commission with the commissioner who happens to be sitting right here in front of me, Tom Wheeler. And he was Deputy Assistant Attorney General for Litigation in the Antitrust Division of the Department of Justice. And he was Director of Office of Policy and Strategic Planning for the U.S. Department of Commerce. He's had multiple publications in the antitrust field. He is truly an antitrust expert. But perhaps most importantly for today is that Jon was one of the maybe the lead litigator in a recent Google antitrust case. And I don't know how many of you have been following that case or know the outcome of that case. He was representing Phil Weiser, who is the Attorney General of Colorado, and the government the court had consolidated Colorado as basically the lead state, along with the Department of Justice, to bring the suit against Google. The Judge Mehta, just rendered his decision this past summer, and I'll just read real quickly. What he said was, after having carefully considered and weighed the witness testimony and evidence, the court reaches the following conclusion. Google is a monopolist, and it has acted as one to maintain its monopoly. It has violated Section 2 of the Sherman Act. Now, that's a little unusual because my background is I was at AT&T for many years, and usually these things get negotiated in some form. And so to actually have and Jon will correct me as I get this wrong, but to have a federal court and a judge decide that in fact someone was a monopolist is a little unusual. The one thing I will say to just protect Jon a little bit, the judge found them guilty of being a monopolist. The judge did not say what the remedy should be, and that's the next phase of this whole discussion. Jon will not talk about remedies. He cannot talk about remedies at this point because of his role as basically Jon was the main person cross-examining witnesses in the trial, and he will be in the process of putting together some of the responses in terms of remedies. So he cannot talk about that today. The other thing I would say, just to remind all of you, is we're doing this a little in an unusual way. There are two parts to this. There's the discussion today at lunch. Jon is mostly going to talk, and then I'm sure many of you will have questions. We're going to follow up with a seminar at 4 o'clock this afternoon, which is in Bell Hall over in the Belfer building. And there you will get a chance to ask questions if you like, more so than probably you will get a chance today, just a small heads up. But with that, Jon, the floor is all yours, and we're all looking forward to being educated.
Thank you, Jon. By the way, when we get to my slide that contains the language that Jon just read, I think we should read it responsively because we'll all know it by then. But I want to talk about this case. Along with lots of other lawyers, I represented a coalition of 38 states. And the way it played out was this. In October of 2020, the Department of Justice brought a complaint focused on what are called distribution agreements. That's what we're going to talk about today. In December, the coalition of 38 states filed a broader complaint. As it turns out, Judge Mehta didn't accept our additional allegations. But we're not going to talk about that today. That's for a different discussion. We're going to focus on what the judge decided in the case that overlapped, that both we and DOJ brought. And we should be clear about this. The Department of Justice took the lead in this and did a fabulous job litigating it. The coalition of states existed because of the vision of some state AGs. The team was led by two AGs, a Democrat from Colorado, Phil Weiser, a Republican from Tennessee, Jonathan Skrmetti, and the original complaint was brought when Doug Peterson was the Republican governor of Nebraska. And so this is a 38-state bipartisan coalition that worked alongside DOJ. Myself, I was co-counsel at trial with a trial lawyer named Bill Kavanaugh, who's a fabulous litigator. I mean, sitting there watching him do this was like attending a master class in how to litigate. He just did a wonderful job. The DOJ lawyers did a great job, but I just want to say one thing before we get into substance. There are a lot of people in antitrust who are high profile and who get a lot of recognition, and they deserve it. But there are a lot of lawyers who work day in and day out in state AG offices who don't get a lot of recognition, but they also deserve it. This is true for the professional staff at DOJ as well. What was really heartening about this was bringing together a coalition of so many states and seeing lawyers, young lawyers, lawyers who had never been at a case this big, because this is an unusual case, who examined CEOs, who prepared witnesses, who appeared in court, who argued motions. This was a wonderful opportunity for them, and it was a wonderful thing to see for the development of better antitrust enforcement in the United States. Because one lesson from this case is having DOJ in the states shows you can't have too many antitrust resources. They all have to work together. But enough about them. I'm going to talk about me. Today, I'm offering you my personal views on this case, on the liability decision. I got to emphasize that my views do not necessarily represent those of the Colorado Attorney General's office, for which I am a Special Assistant Attorney General. But what I do believe, and I think this is not important just to lawyers, this is, after all, a public policy school, not a law school. It's important for policy makers of all stripes to understand how the law can work, should work, maybe ought to be changed to work in dealing with some of the biggest competition issues of our time. It's a landmark case. So I'm going to give you my views, but really, I'd like you all to read the opinion. It's almost 300 pages long. Read the opinion, read the commentary of people who disagreed with the opinion, and reach your own views. Because this is, I think, a seminal case in the way that governments come to treat big tech. And it will influence us in many different ways through the years. So I encourage you to reach your own opinions. Before we get into this, let me give you a little bit of background, because there's some key concepts here that are important to understand if we're going to understand what the judge did. The first is a browser, right? Chrome, Safari, Edge. A browser is not a search engine. It's not a general search engine, right? This is actually a point on which some people get confused. The browser is the user interface you use. You can navigate to different parts of the web on it, not always having to use a search engine. But distinct from the browser is the general search engine. We're talking about entities, and I'm just referring to the United States now, like Google and Bing and DuckDuckGo, and a company that was in business, which we'll come back to, called Neva. Now, when you run a search on these, and we'll show you an illustration of this, you get a page back, right? We've all done this. We run searches, we get this page. That's the search engine results page. It's where you see what the answer to your query is. Those three things are all visible to us. What's not so visible, but what was at the heart of this case, was a distribution agreement. So think about this. Google makes contracts, distribution agreements, with different companies, Apple, that affect how you get to choose a general search engine. Okay, and we're going to talk about the terms of that. And we're going to talk about defaults. So I'm going to use Apple probably as an example more than any others, but there are others. You get a new iPhone. You open up Safari. You see the integrated bar where you can type a search query. You're using Google search. It's the default. It's there. There are ways to change it, and we'll talk about that. But the default is what's there without you making any choice. There's a default on Apple. There's a default on Android. There's a default on Mozilla. And then you say to me, well, there are other ways I can reach a general search engine. Yeah. These are search access points. You don't have to use a browser. On Android, a bar will appear right in the, and people here have Android phones, right? They know there's a bar in the middle of the Android home screen that you can put a search query in. You could, if you had first encountered the internet in the 1990s, like some of us whose names I won't mention, like me, go to the bar and actually type www.google.com, and that would take you to Google, right? But the default in the browser is going to be at the heart of what we talk about. The other background is the legal concept that I want to talk about because it's important, and that's the concept of monopoly maintenance. So think about this. Imagine a company that begins in a very innovative way, lots of really interesting new products. But then, after it's become a monopoly, uses anti-competitive conduct to keep its monopoly shares. Okay? That's, in US law, monopoly maintenance. It can happen when a monopoly takes steps to keep its competitors from being able to offer their new products into the marketplace. The leading case on this, prior to August 5th of this year, maybe still, was the decision in United States versus Microsoft, the big antitrust trial at the end of the 20th century, which laid out circumstances in which Microsoft was found to have illegally maintained its monopoly in Windows operating systems, right? The next big case, 23 years later, is this one, the Google search case. It's been a long time. There are others on the way. Cases brought by the federal antitrust authorities against Amazon, other case against Google, one against Apple, but this was the first. And so it's worth just briefly looking at, reminding ourselves of some of the salient points of Google's own history. In 1998, Larry Page and Sergey Brin create Google Search, okay? It's a big innovation. In 2000, Google introduces ads, right? So now there's search results and ads. In 2009, Google's share of general queries is 80%. By 2020, its share of general queries is just over 89% and almost 95% on mobile. Those are very high numbers, and we'll come to that. And significant revenues come out of the advertising that gets put on the search engine results page. Google has a classification for financial reporting called Search Plus, which is not just limited to search, but it reported revenues in 2022 of 162 billion. Of importance for us, it's that the text ads, and we'll see a picture of these, every one of you has seen them. The text ads contribute a considerable percentage of the revenue to Google. They're important. So John read you this, so you know how the case came out, right? The judge ruled that Google is a monopolist and has acted as one to maintain its monopoly. That's the monopoly maintenance point. And here's the classic way antitrust thinkers might consider monopoly maintenance. A new entrant with a new, different approach enters the market with a new product or service, okay? But there's a monopoly. The monopoly impedes the new entrant from reaching consumers, but not by offering a better product or service, but rather by restraining competition, which means consumers lose the value of having the different choice, the differentiation, the new product or service that the new entrant wanted to bring. Okay. Anybody here know what NEVA was? Anybody ever use NEVA? Remember, the number is 0 when we get later into the discussion. Because NEVA is what the judge called a case in point. And the quotes here, I've tried to put quotes on anytime I cite the opinion. It's a case in point. It was a search engine with a different idea. Right? I presume there are a lot of people here who use Netflix. And probably everybody therefore has chosen whether to pay less and have ads or pay more and have no ads. Well, NEVA was kind of like that idea for general search. A subscription-based general search engine with no ads asserted that it provided greater privacy and some additional software features that were integrated. It went out of business in 2023. And it was because the judge said NEVA could not gain a foothold in the market, in part because it was relegated to less efficient means of distribution, such as app downloads. Okay, so we talked about distribution, we talked about the default. You all know you can go to an app store and download. People have presumably downloaded, somebody here has downloaded DuckDuckGo's browser, right? So you could do that, but the court finds that less efficient. And that NEVA's inability to get users was a primary reason for its withdrawal from the market. Now, I'm not going to tell you every day in trial is incredibly exciting. We had 42 days of trial that went from September to the Thursday before Thanksgiving last year. There were great lawyering, really interesting witnesses, but every once in a while, something happened that really, I thought, caught everybody's imagination. And one of those moments was when this man, Sridhar Ramaswamy, testified. He had been a longtime Google executive. He became CEO of NEVA, the subscription-based search engine that we're discussing. And this case was not tried in front of a jury. It's a so-called bench trial, meaning there's only a judge. I shouldn't say that, the judge might be listening. There is a judge without a jury. And one of the consequences of having a bench trial is that the judges, I think more often, will themselves question the witness. And Judge Mehta did that to great effect during the trial. And when Dr. Ramaswamy was on the stand, the judge asked him a question. Here's how the judge depicted it. When the court asked why Google pays billions in revenue share when it already had the best search engine, Mr. Ramaswamy answered. An answer that was among the testimony that the court found when he said Dr. Ramaswamy was a particularly compelling witness. And what he said, I've given you a little bit of the quote, but let me tell you how the judge described it. He answered that the payments provide an incredibly strong incentive for the ecosystem to not do anything. They effectively make the ecosystem exceptionally resistant to change, and their net effect is to basically freeze the ecosystem in place. That's how the judge heard, that's how the judge recounted Dr. Ramaswamy's testimony. The next sentence in the judge's opinion, no one would ever describe a competitive marketplace in those terms. The NEVA story isn't the whole story of an opinion that lasts almost 300 pages, but it's a good illustration of the concerns for which we want US antitrust to work, to maintain the ability of new entrants to come into the marketplace. So let's go through it step by step. And by the way, I'm just doing some of the issues in this opinion, right? I mean, there's a lot of issues in this opinion. How does general search work? Well, You go out, there's only two of these in the United States, Google and Bing. You go out and you look at the universe of available information sources on the web, trillions, and that's crawling the web for content. Then you index the information, hundreds of billions. And that's creating an index that you can consult to see if it contains information relevant to a query. Then you have to retrieve the information in response to a search query, right? I search Boston Red Sox, and a smart search engine would result, season's effectively over, forget about them. Okay. And then, of course, these relevant results are ranked. The Google algorithm for these organic links, the blue links, ranks basically in terms of relevance and displays those rank results on the Google SERP. And the SERP can look like this. This is brown shoes. This is an inside joke for American antitrust lawyers. Only Gene Kimmelman gets this joke, but he does get it. So let's go in terms of when these things started to appear on the page. This is a search for men's shoes. This is the free result. That's what I'm calling the blue link, right? Everybody's seen this. These are text ads. They look a lot like these results, right? But they say sponsored because they're paid ads. These are text ads. The judge found this was a market for users. This was a market for advertisers. And then there's other kinds of ads, like these product listing ads, shopping ads, that have, for example, a picture that the text ads don't. And the first question, in some sense, that the judge had to answer is, was Google a monopoly in these markets, the blue links and the text ads? And the test under US law is not a, as a technical matter, you could say a monopoly has to have 100% of the market. That's not what US law means. What it means is the ability to act unilaterally without regard to competition. In particular, the legal standard the judge relied on was a firm is a monopolist if it can profitably raise prices substantially above the competitive level, right? In an entirely competitive marketplace, you raise prices 10%, people will go find the other competitor. If they don't have other choices, one measure of that is the price goes up, people don't leave because they don't have an alternative. And one of the ways to look at that is by market share. It's the possession of a dominant share, looking at, say, 2/3 of a market or more. The judge found that, in fact, Google is a monopoly. Well, it's a monopoly more than once in this case. It enjoyed 89.2% of the market for general search services, the judge said, and as I said before, almost 95% on mobile. That's well above 2/3. On text ads, 88% in 2020. So it's a monopoly. Now, tell me something's a monopoly. If I tell you something's a monopoly, let's flip it. I'll tell you it's a monopoly. You would say to me, in what? Right? When somebody's a monopoly in something, a market. This goes to a question called market definition, right? Because what you're doing is you're finding a set of products or services, and then you're seeing if a company is a monopolist in it. How do you do that? You look at whether users or buyers, from this perspective, find another product substitutable. It's sort of the example we just gave. It's very similar. If all the firms in a market raise their price, if there were a single monopolist, or you take a single company, it raises its prices 5 or 10%. You see whether people go anywhere or not. It's the hypothetical monopolist test. But here's just an example from the trial. Okay, I'm going to assume that everybody in this room has used both Google and Amazon at least once. Anybody disagree with that? Okay, so we're going from 0 now to 100. This is good. Are they competing against each other? Right. The term that was used, by the way, is Amazon was called a specialized vertical provider. Amazon, Expedia, companies like this that you can buy things on that have search functions that tend to be limited in range. Are they the same? I mean, you can go to Google and you can go to Amazon and you can type in running shoes, same query, you get results. So one critical question in the case was, are they substitutes competing against each other? Or are they steps on a journey? What economists would call complements. Two products, demand for one actually increases demand for the other. The economic expert the states employed in the trial was Jonathan Baker, Dr. Jonathan Baker, an esteemed antitrust scholar and economist who did a wonderful job. And he gave this basic example, which the judge quoted when he said, even for overlapping queries, general search engines and SVPs can serve as complementary search platforms. As Dr. Baker opined, it wouldn't be surprising if, for example, a search user entered a query for red shoes on a general search firm, saw a link to a shopping SVP, and clicked on it and entered a search for red shoes. So why am I going into this market definition point, which is pretty obscure as a matter of antitrust law? It's to set up the point that we need to understand how markets operate. We need to look very closely how markets really operate, what they are really doing. And what the judge found about Google, about general search, is that general search engine is performing a unique function. It's both a reservoir of information and a conduit to other sources in the web. You know this. The point of Google or Bing is to find you all sorts of information. The point about Amazon is to find you products. The point about Expedia is to find you information about travel. In fact, Dr. Baker did a test. He entered the query UFOs on Google and Amazon, and on Google, he got nearly 2 billion search results. When he entered it on Amazon, he got 10,000, and they were all products. When he entered it on Expedia, he got 0. In other words, the breadth of search was a fundamental in explaining the difference. But what we haven't talked about yet is how Google makes money. This is a diagram that the judge reproduced in his opinion to show network effects. But let's just walk around this circle. If you have more users, you can attract more advertisers, right? So many multi-sided platforms on which we all do business. This is the core economics of it, right? You attract users, the advertisers want to be where users are. This is just sort of the most fundamental kind of indirect network effect. So you get more advertisers, but that's not all you get. You get more data. You learn more about what users want to see, so-called long-tail queries, for example, queries that are relatively rare. A long-tail query may not always be long-tailed, right? How many people searched for COVID in December 2019? That must have, I don't know for sure, but I'm guessing there was a long-tail query. It wasn't in March. But you get information from users. If you have more users, that let you do a better job on the queries when they're rare. Which means with this, you get better search and more relevant ads, which gives you more revenue to invest in development and distribution. It's self-reinforcing. And we're going to come back to that because it plays an important part in what the judge decided. So let's go back to the point. How do general search engines get to users? How do they reach you? Or maybe how do you reach them? What the judge found was that most users access a general search engine through a browser like Apple Safari, or a search widget that comes preloaded on a mobile device like the home screen on Android. Those search access points are preset with a default search engine. The default is extremely valuable real estate. And for years, Google has secured default placements through distribution contracts. Google pays huge sums to secure those. Here's what they look like. This is a DOJ expert. We're going to talk about Dr. Antonio Rangel used this slide. You open up Safari on Apple. Default is Google. You type in this part of an Android home screen. Default is Google. You go to Firefox. You type in. Default is Google. Okay? So when we see that, we can examine now the rest of the ruling. We have monopolies. We know what markets they're monopolies in. We understand how sort of the process works. What the judge found was that these distribution agreements, remember, what set the default, what grant Google the default, are exclusive and have anti-competitive effects. Google has not offered valid pro-competitive justifications, and Google has exercised its monopoly power by charging super competitive prices for the text ads. I want to go through these pieces for a few minutes. The judge starts off by saying these agreements are exclusive. So that's important in US law for the reason that's on this slide. Exclusive agreements can help or hurt competition. This is really important. You got to know the facts. So let me give you two examples. A monopolist manufacturer of, say, plumbing equipment pays the only distributor, right? There's a manufacturer, there's a distributor. The manufacturer pays the distributor not to carry its own only rival. Exclusive, I don't know that there's a lot of debate about this, and there's a leading case on it. That's illegal. That's just using money to keep the competitor from coming into the marketplace. By contrast, suppose you got a new idea in a new company, and you go to a distributor. This is a catalog. This is like, remember, they used to be catalogs, but for an online listing, and you pay for exclusive place to show up in the catalog because you want people to notice you. You have no market share. You've got a new product, and you're paying the money to bring consumers a new product or service of which they have no knowledge. I think that would generally be viewed as pro-competitive. So what's going on here? Well, Google's browser agreements are exclusive insofar as they establish Google as the out-of-the-box default search engine, right? There's one default, Google has it. And importantly, users are free to navigate to Google's rivals through non-default search access points, right? You could download the apps, we talked about that, but they rarely do so. They rarely do. In 2020, only 5.1% of all search queries on iOS devices, the Apple devices, went to a rival general search engine through such a non-default point. In other words, they have a big effect. Now, we know they're exclusive, and we're going to take a minute to talk. I think because of time, I'm just going to do Apple and skip Android, but just to take a minute on Apple. Google pays Apple a share of its search ads revenue in exchange for the default status, okay? In 2022, Google's revenue share payment to Apple was an estimated $20 billion worldwide. Queries entered through the Safari default, this includes both mobile and desktop, account for 28% of all the queries in the United States, okay? That's what the Apple agreement does. On Android, I'm going to skip the slides, but people who use Android must understand, I think, that Google search comes pre-installed, for example, on the widget. And what you may not know is that an incentive for Android manufacturers to do that is to get the Play Store. Okay, anybody here have a smartphone that doesn't have an App Store on it? If you still had a 2007 Apple iPhone, the first generation, the answer to that question could be yes, but it hasn't been that way, and it's not practical. And there was testimony at trial saying, for example, from a Verizon executive, a device would need to have an App Store on it in order to be successful. So having to get the App Store is a reason why Android manufacturers agree to the pre-installation of Google search. In terms of the revenue sharing, the money that can be made by accepting Google, the judge was very straightforward. No rational market actor would sell he calls it a MATA compliant device, but an Android phone without ensuring it earns search revenue through a revenue sharing agreement. In fact, he noted that Google had identified no Android device presently sold in the United States that did not have a revenue sharing agreement. Okay, Android, Apple, we're talking about mobile, and that's important. These market share numbers are not like the market share numbers in other parts of the world. People know that. But in the United States in particular, Apple is the market leader. This is a public assessment as of August of this year. But combined, they're 99.6% of mobile. So Google has defaults on both. There are essentially no other mobile operating systems through which one can access the web. Okay, this is all good. It's interesting. But does this stuff harm competition? Okay. I want to go through a few questions that I think, my view, dominated the trial. I mean, what were sort of people thinking about all the time? There's a lot of detail work, and it's really good lawyering by lawyers from DOJ and the States. But there are also some big questions. One big question, maybe the big question, was, what is Google paying for? In 2021, Google paid $26.3 billion in revenue share to browsers, OEMs, the original equipment manufacturers, right? Samsung, the hardware manufacturers, and mobile carriers in the US. We already saw that in 2020, Google paid Apple about $20 billion. These numbers are not apples to apples because one is US, the other is global, but they both give you a sense of big numbers. So what is Google paying this money for? Second, is competition one click away? As far back as I think this was 2009, the then CEO of Google, Eric Schmidt, said, we're one click away from losing you as a customer. So it's very difficult for us to lock you in as a customer in a way that traditional companies have, right? Here's the argument. You can switch your default search engine. No doubt there are people in the room who have. I don't want to embarrass you by asking for a show of hands. So it can be done. Google's argument was it's only one click away. It's easy. This turned out to be a critical issue in the trial. What would be harm to competition? So you now know they're the agreements. You know they're exclusive. You know Google pays money for them. You know a core argument that everything's one click away. So if you had to identify some outcomes that would be harmful to competition, anybody want to offer one? What would you look for? Okay, can I try? You might look for things like this. You might ask, particularly if you're getting a free good, which is advertising supported, are there more ads on a page than a consumer likes and there would be in a competitive marketplace? That's always the comparison. Are the prices for advertisers higher than they would be in a competitive marketplace? Are there fewer new entrants than if there were a competitive marketplace? Is there less innovation than would be produced in a competitive marketplace? Are there bigger barriers for consumers to surmount? These are the kinds of things that can be harm to competition. It's not all of them, but it's some. So let's go through these questions, because the judge answered them all. Why did Google spend the money? But first of all, let's understand it was important. In 2017, Google estimated that its default placements drove over half of its overall search revenue. So it's a big percentage of the Google search revenue. Secondly, in 2020, Google's internal modeling projected that it would lose between 60 and 80% of its iOS, think Apple, iOS query volume should it be replaced as the default general search engine on Apple devices, which would translate into net revenue losses between $28.2 and $32.7 billion. One answer is Google spending the money to get those users, to keep those users, and that without it, they would lose a significant number of the users. Well, yeah, but what about the second question? Is competition one click away? That's, the judge said, Google often warns that competition is only one click away. But the judge said, however, the paltry penetration in the market by competitors over the years has been a refutation of that theory by tangible and measurable results in the real world. In other words, my interpretation, I'm not saying the judge thought this, if it were that easy to switch away, of course, one question is, what would Google be paying for? But a second question would be, well, then why don't the other people have bigger share? Okay? And by the way, it's not one click. Dr. Antonio Rangel did a demonstration of what he said were 12 steps to replace the Google search widget on Android. Okay, so are there anti-competitive effects? The court said there were. This is legalese, but I think it's important. The key question then is this: do Google's exclusive distribution contracts reasonably appear capable of significantly contributing to maintaining Google's monopoly power in the general search services market? The answer is yes. Why? Well, go to the second paragraph, the bolded language. Because they ensure that half of all the general search engine users in the United States will receive Google as the preloaded default on all Apple and Android devices, as well as cause additional competitive harm. And these clearly have a significant effect in preserving monopoly. And what are the anti-competitive effects? Well, let's go through some of them. One of them is, of course, you got a potential market, but there are fewer opportunities for competitors. Think of these two numbers. 50% of all queries in the United States are run through, my phrasing, the contracts, the default contracts, the places where Google has a default. In addition, 20% flow through Google on user-downloaded Chrome. Let me explain what that means. Because the Android users in the room are going to say, but Chrome comes on Android. It does. But this 20% is people who download the Chrome browser themselves, and that counts for another 20%. Google sets itself the default on that. Nobody said that was illegal. Google owns it. But it shrinks the number of users that are available for competitors to try to reach. So it had a significant effect in foreclosing users. But this I think is really important. Scale. These are scale businesses. And the input, the scale advantages come from having more users, which means fewer users equal lower scale. They deny the exclusive agreements deny rivals access to user queries or scale needed to effectively compete. Scale is the essential raw material. Because we saw it before on the wheel chart. It leads to better search results and better ads. You don't have users, you can't get scale. You can't be as good. And so other general search engines have remained at a persistent competitive advantage, and new entrants cannot hope to achieve a scale that would allow them to compete with Google. And then finally, innovation, less investment. The distribution agreements have reduced the incentives to invest and innovate. So let's go back to some of these challenges for a minute. This I thought was an interesting point. And the judge asked about it at trial. Where's the entry been in this market in the last 15 years? Have new companies come in? What's been happening? DuckDuckGo and Neeva. People here use DuckDuckGo. Some people do, yes? Yes, okay. DuckDuckGo and Neeva are the only two notable market entrants in the last 15 years. Each attempted to innovate, DuckDuckGo on privacy, Neeva through a subscription-based model, but found only limited success, DuckDuckGo, or left the market altogether. In fact, the DuckDuckGo story is interesting. DuckDuckGo went to Apple, and went to Samsung, and went to Mozilla to try to get placement as a default. For example, they went to Apple and said, you've got a private browsing screen tab. Make us the default on private browsing. We're a privacy company. It never worked. It never happened. DuckDuckGo's impression was that the common concern shared by these browsers was their contracts with Google. In other words, I read the testimony, heard the testimony trial to suggest that DuckDuckGo thought these browser companies did not want to cross Google. But it wasn't just small companies. Apple's a big company. Apple has the capacity to have a general search engine. I mean, it has the technological know-how. It has taken steps to grow its capacity, but it hasn't entered general search. And the judge said the prospect of losing tens of billions in guaranteed revenue from Google, which presently comes at little to no cost to Apple, disincentivizes Apple from launching its own search engine when it otherwise has built the capacity to do so. In other words, the exclusive agreements have yet another effect. They discourage a company who would seem to be well positioned to enter, not to enter. The clause in the middle, which presently come at little to no cost to Apple. The revenue sharing, it doesn't require Apple to build new products or deliver new services. It's revenue sharing on ads that Google places. It comes at little to no cost. So it's a disincentive to entry. In other words, the defaults, by having this go around, give Google bigger and bigger scale advantages, make it harder for anybody else to enter, and disincentivize the people who are getting paid. Well, this raises the question of quality. Scale equals greater quality. So if the Google search engine is getting better, what's the problem? Here's an excerpt from two pleadings after the trial was ended. Google said, browser developers such as Apple and Mozilla have chosen to set Google as the default based on quality and price, the hallmark of competition on the merits. We said, the state's pleading, Google's claim that partners like Apple and Mozilla viewed Google as having higher quality search results than competitors in 2018 or 2020 is not a pro-competitive justification, but rather the fruit of the poisonous tree. This is a phrase American lawyers love to use anytime they get a chance. And some people in the room may have fallen prey to that desire. But the critical point here was we believed that a monopoly couldn't harm competition keep other people out of the market who wanted to compete, then claim they got better as a result and therefore there was no problem. Quality was not a defense, we thought, in that circumstance. And by and large, I think the judge came to an equivalent conclusion. When he recognized that Google had used scale advantages, more users, to improve its search product, but and monetization, but noted that without access, other general search engines have remained at a persistent competitive advantage. So naturally, the browsers, for example, prefer Google because of its search quality, but this is the antithesis of a competitive market, the persistent competitive analysis. Last part of the discussion that we need to have. Okay, what was the first question? Why did Google spend the money? So maybe they have a really good reason for it. I mean, this is the way US antitrust works, right? Even if there's some harm to competition, the defendant gets to say, yeah, but we have a really good reason to it, and we couldn't do it without this mechanism. Google contends that the contest to be the default presents search engines the opportunity to win incremental promotion, thereby incentivizing other firms, to make quality improvements. Judge said, the defaults are more than just incremental promotion. They supply Google with unparalleled query volume that's effectively unavailable to rivals. I've gone through a lot of material here, but I hope there are a couple of concepts coming through. Scale, users, advantages, accrue to Google, not available to competitors. Indeed, the judge says there's no record evidence that competition for the default has motivated, he means these other general search engines, to make quality improvements. I noted that prices go up, which is a sign of monopoly pricing. I won't go through the details, but the point is, in a competitive market, remember when we were doing what the harm was, we kept saying compared to a competitive market? In a competitive market, then, Google could still earn a profit from the sale of an ad, but it could not achieve the monopoly profits that it presently does in the absence of rivals, okay? So, we started with monopoly maintenance. Let's finish with it. Read what the judge says. No, I'll read it. How's that? Google may have gained its initial dominance in the general search market, services market competitively, but this case is not about Google's initial acquisition of monopoly power. It's about Google's efforts to maintain this position through means other than competition on the merits. Like Microsoft, remember we talked about the Microsoft case? Google has thwarted true competition by foreclosing its rivals from the most effective channels of search distribution. That's the conclusion. This is the monopoly maintenance case. It's an important monopoly maintenance case, but I think I have 3 minutes left, and I'm going to do 3 other things. 4. You guys are policymakers. Some of you may be lawyers. I'm betting most of you are not, and that you have no intention of becoming lawyers, and I won't give you a judgment on whether that's a good or bad career choice. But you're going to be policymakers, and policymakers have to listen to lawyers and technologists and economists and think about issues. I think this decision is important for reasons beyond the scope of what happened in this case, although that's incredibly important. I think the discussion of one click away, the use of behavioral economics to understand how consumers actually regard the choices presented to them, is going to be very important. I think lawyers like to argue the language of contracts, or they have theories, or economists have theories. What the judge did relentlessly was say, here are the market realities. Here are the market realities. And thirdly, I think this shows the importance of competition. In other words, yes, there were network effects. Yes, there were scale effects, but there could be competition. There's no reason there couldn't be competition. What kept competition at bay were the anti-competitive acts. I say this because those of us who think about big tech platforms say, well, there's always network effects. There's always scale advantage. They don't preclude competition. Last slide. Back to me. So I took this picture on November 16th, 2023, the morning of the last day of trial, standing outside the courthouse, because I thought I should have a remembrance of being at this trial and tangible proof that I own a tie. It was a fabulous opportunity to be on this team. I wasn't the most important lawyer by a long shot. I didn't do the most. DOJ lawyers did a great deal. Bill Kavanaugh, my state colleagues. But it was a privilege to be on this case, and it remains a privilege to work on this case in any capacity. These are one of these cases that come along not that often. And I took that picture because I was appreciative of the opportunity. You all, in your different ways, as you take your public policy careers forward, are going to have opportunities like this. Sometimes they seem deserved, and they are for people of the talent that you all have, but they're also special. They ought to be remembered, and we always should remember how lucky we are to have these kinds of opportunities, and we should always remember to say thank you. So I'll say it. Thank you.